This is another talk I did not wish to give before making and posting the video which I've been wishing to make, or for that matter before the video which I feel compelled to make before making the video which I rarely ever wish to make. But I must now make and post this first, owing to the urgency of the situation. This has been a year of loss. I'm used to that. I have, and I am yet shy of 60, outlived my political party as it was. I have outlived my communion, which is now not in a state of pre-Tractarian national apostasy, but of worldwide heresy. I have outlived my old school. I have outlived my university and my law school as they were, as they used to be, with all which they represented. There are moments when I worry that I shall outlive my country. I have not yet quite lost hope for my country. The Constitution has been passing stress tests for the last 27 years, and indeed for 231. On the other hand, the American people have been failing the stress test for at least that long. But this has been a year of loss. I have lost a right smart of respect for a right smart of people whom I used to respect. I have increasingly lost patience, and though I ought not to do so for cardiological reasons in my own interest, I am increasingly on the verge of losing my temper. This is so because this is by no means the first, but merely the latest year of loss, the loss of reason and of logic, in a world in which statements begin with, "I feel," rather than with, "I think," or "I have concluded." The loss of expertise, not least amongst those continually bemoaning the loss of expertise, who seem to be suffering almost universally from a sort of contagious and often self-induced Gell-Mann amnesia effect. Yes, I include Tom Nichols, one of those for whom I have lost a right smart of respect. People with expertise in one field ought to confine their more pontifical and magisterial pronouncements to the field in which they are experts, and remember that they are laymen, and often not particularly educated or informed laymen in other fields. But they don't. They keep running their mouths, and they keep brandishing their irrelevant credentials in the apparent belief that this gives them some right to have their lay, amateur, inexpert opinions given special deference. We live in a world of people who have every reason to know what they're talking about, and talk nonsense anyway for the sake of partisan power, and of people who have no qualification to talk about all the things they talk about which they know less than nothing, in an inverse relationship to the volume at which they scream about them. A world in which public debate too often involves screaming hysteric ninny Olbermanns and would-be barriers. It ought never to shock anyone that current and ex-prosecutors, from the Harrises to the Comeys to the Kirschners of this world, are equally willing to posture with mobs of the far right and of the radical left. All they really care about is power without accountability. They are natural statists. Never forget the book of Job. Satan started out as a rogue prosecutor. And, of course, there are, alongside the dubiously expert and the intellectually dishonest, the credentialed, though by no means educated, who seem to believe that having a BA in creative writing, say, of government, makes them experts on everything from epidemiology to constitutional law to history. The Nicole Hannah Joneses and Jamel Bouies and Michael Antons of the world. Yes, I know the first and last of these have advanced degrees in journo-fiction and liberal arts basket-weaving studies and such unscholarly indisciplines as well. Yet they insist their credentials in one thing make them expert in all things. These don't, and they aren't. This should be a serious loss to the intellectual life of the nation in any case. It is fatal to our national ability to talk sensibly about things when it is combined with smug self-righteousness. A smug self-righteousness for which there is no warrant. Partisanship, not least in, perhaps especially for experts, actual experts, rots the mind, even to my grave disappointment, where the mind is housed in a head adorned by a pope hat. The chattering classes and the rioting classes alike preen themselves on their parades of virtue that claims to have done great things for the little guy. Horse shit. They are largely responsible for some of our worst losses. The loss of the presumption of innocence regardless of the skin color, office, political standing, or views of the accused. A transactional approach to justice. A conflation of victim with complaining witness. A renewed, if reversed, racial essentialism, the one-drop rule, the return of racial preferences and racial prejudice in hiring and other areas, the return of segregation, and all the rest of it, now gussied up and made anodyne by calling these things safe spaces and the like. And they pride themselves on this and claim that it proves them good people who have done good things for the downtrodden. They aren't, and they haven't. It's just a bit over 32 years since I first stepped into the courtroom as a lawyer. I was then what I am now, and have always been, and ever shall be, a conservative Democrat, for whom the modifier is far more important than the party designator. According to social media, I am, as a conservative, irremediably evil. According to social media, I am, as a white Southerner and a man, irredeemably evil, inherently racist, incapable of redemption. According to Trump shirt social media, I, as a Democrat, am inherently evil, an enemy of the people, bent upon the destruction of the Republic, which, as it happens, my family was instrumental in creating. According to leftist social media, I am, as a conservative, not merely evil, but by masquerading as a Democrat, a party which, as it happens, my family was instrumental in creating, a category traitor, an infiltrator, and a mole. It's just a bit over 32 years since I first stepped into a courtroom as a lawyer. This was half an hour or so after I received the official notification that I had passed the bar. It was a quarter of an hour since I'd been hastily sworn in by a local judge to try a 4-count felony alone to a jury. Associates at big city white shoe law firms, some of whom in the 7 years in which they are trying to make partner never see the inside of a courtroom, can and do wait for the big, gaudy, capital extravaganza swearing-in ceremony. I didn't have time to wait. The appointed client didn't have time to wait. And in my small town, the justice system didn't have time to wait 2 months for that. The defendant I was representing was one of 2 main suspects in this armed robbery. The armed robbery of the local VFW post after bingo night while the veterans and their wives were counting the take. The defendant, like the other main suspect, with whom he had a beef over a woman, was a young African-American with a rap sheet long as a well rope. The town was a rural southern county seat, which 70 years ago was notorious for a prosecution of the alleged rape and murder of a white woman, which, though now mostly forgotten, was in its day mentioned in the same breath as the cases of Emmett Till and of the Scottsboro boys. This is usually what happens when people forget the law and the requisites of justice and hashtag stand with her and hashtag I believe her and hashtag always believe the woman. When people mistake allegation for proof and complaining witnesses for as yet unproven and unexamined victims and survivors. In other words, within an hour of my having received notice that I'd passed the bar, I was responsible for the defense of an African American defendant in a rather notorious southern town who, being charged with the armed robbery of the VFW hall, was up against not only the prosecution and all its resources, but God, the flag, motherhood, baseball, apple pie, and the American way of life, and up against his former friend and fellow prime suspect, who had elected to direct suspicion to my client and away from himself, collaborating with the prosecution. The armed robbers, of whom there had been two, had been masked and gloved. Neither could really be identified. The one bit of evidence which put my client at the scene was a thumbprint on a piece of duct tape, for which he offered the somewhat unconvincing explanation that the duct tape had been in the possession of the young woman over whose affections he and the other prime suspect had been fighting for months, he and the other lead suspect having both had access to it at her house before the robbery. It was not my job, it is never the job, to pass judgment on what the client claims in his defense. My job was, it is always the job, to give the best defense possible and to accept that the client is innocent until the trier of fact in a properly conducted trial free of reversible error says otherwise, which it is the job to avoid having happen. That's true whether the client is a black policeman or a white robber, whether it's Kevin Spacey or Harvey Weinstein or Ghislaine Maxwell, Claire Bronfman or Bill Cosby or the local pimp, Roger Stone or Mayor Pugh of Baltimore, Michael Reinold or Derek Chauvin or Stephen Cannon, the McCloskeys and Antifa alike. It was acknowledged that there was a roll of duct tape already on the premises at the VFW post. The prosecution was reasonably certain of the conviction. So was the local prosecutor, a man whom I afterward had occasion, in a fit of exasperation, to describe as the sort of fellow who no doubt went to bed every night in three-piece tweed pajamas. To make assurance doubly sure, however, the prosecution had brought down an expert witness from the crime lab to testify to the fingerprint. What they had failed to do, and what they failed to do at trial, was to prove the identity of the thumb-printed piece of duct tape with the duct tape at the scene. They did not have an expert to testify that it was of the same make, weave, paint, material, adhesive, and identity of the brand of duct tape at the scene, much less that it was off the same roll. In fact, as was proven at trial and eventually confirmed by the crime lab, it was not. I secured an acquittal for my client, though he was not a man who could be kept out of jail indefinitely on other and subsequent charges, on my first day as a lawyer. The prosecutor was so affronted by this that he declined to shake hands or to congratulate me in any way, which set the tone for our subsequent dealings and my subsequent description of the man. Not so very long after, I encountered big city, white shoe, big law associates in another case, the members of an actual pro bono section at a large and politically connected law firm, buying indulgences by having this pro bono section. The case was one of resentencing a convicted hitman for a drug ring, whose guilt was not in question, but whose sentencing had been marred by jury tampering. A very strange man with a Charlie Manson smile. The only gay hitman I've ever encountered or heard tell of, who took his fee in sexual favors from young male addicts in part. And the only hitman I've ever encountered whose weapon of choice was an axe. I asked him about that latter and received that Charlie Manson smile in response, and the explanation, "I'm just really into my work." He was not a good man. He was not a pleasant client, nor one I should have chosen. I was assigned to aid the big city lawyers because between the four of them, all 6th or 7th year associates, they had between them tried a dog license case and an administrative appeal and needed their hands held in a courtroom. But even our cut-rate Charlie Manson deserved due process of law, and not because he gets intersectionality points for having been gay. Within a very few years, I left the active practice of law, and certainly of trial law, of litigation, resigned disabled after a complete breakdown in health. I had inherited from my mother's side of the family a tendency towards, and though it was undiagnosed at the time, had already a history, beginning in or before my law school days, of many strokes. I'd inherited from my father's side of the family an unpleasant habit, undiagnosed at the time and for some time after, of asymptomatic heart attacks, beginning in or before my law school days, as we now know. And all of this complicated by undiagnosed and untreated diabetes. There are reasons other than my looks and my personality for my being single. All the same, in the intervening years, I was called upon by my old clerkship days firm, by the successor firm to my old firm, by the successor firm to the successor firm to my old firm, as well as by various alumni of my old firm, for some degree of work. As I am, despite my being now functionally fully disabled since the triple bypass and subsequent surgeries, called upon for this assistance unto this day, when and as I am well enough to give it. I have even now a certain gift of draftsmanship, and particularly of appellate draftsmanship, as well as a flair, when necessary, for the most dilatory and chicken shit of objections to discovery. My advice is thus yet sometimes sought. In these intervening years, evil years though they have been from the perspective of my bodily health, I have played a role in securing justice for many a client, and always for criminal defendants and for civil plaintiffs. I do this not despite my being a conservative, but because of it, and it has but reaffirmed and reinforced my conservatism. This, of course, is conservatism in the American sense, a commitment to conserving the classical liberal principles of the founding as formulated by the framers. According to social media, of course, and much of the press and the punditerati, these principles are institutionally racist. The framers were proto-Klansmen, and conservatives defend these things only out of self-interest, bigotry, evil motives, and profiteering. For 3 decades, I've drafted the pleadings, drew up the briefs, for public employee union pension funds suing self-dealing banks and brokers, taxpayers victimized by the combined arrogance and incompetence of no-notice taxing authorities, gay and lesbian parents facing child custody disputes, the poor and the disprivileged fighting against the "we know better than you" state in the guise of Orwellianly misnamed child protective services, victims of predatory mortgage lenders in a town's oldest desegregated neighborhood, little old ladies being bilked of their annuities and pensions by their psalm-singing evangelical right nephews, decorated African-American cops as whistleblowers taken on Southern police departments, law enforcement officers wrongfully discharged for their political views, and enough other Section 1983 litigants to fill the Crawford boxes. I have done this as a conservative, a man dubious of public employee unions, supportive of civil unions but opposed to extending to same-sex unions the bundle of privileges which are legal marriage as a legal concept, privileges justified only by the state's interest in the orderly disposition of heritable property from grandparents to their naturally begotten grandchildren by blood, a believer in law and ordered liberty. I have done this as a conservative because I am a conservative, explicitly because I'm a conservative, a believer as the left now are not, in equal justice under law, the adversary system, the right to confront and examine witnesses, the quantum of proof, the presumption of innocence, and the entire Anglo-American common law approach to justice and to rights, civil and procedural, which the left is so eager to jettison and pride themselves on being eager to jettison. This does not make me special. It certainly does not make me heroic. I am not. Some of the cases I worked on and drafted the briefs for have made black print, though not even the most grandstanding senator would call them super precedent or indeed have heard of. Nor, and you may call me merely a glorified law clerk nowadays if you like, is my name plastered all over the reporter system on these appeals. My health went to hell in a handbasket, and part of my memory, brains, and stability with it decades ago. Shelled acre of what's now wasted no man's land in my prefrontal or western frontal cortex, and I had to give up these excitements. Yes, I really did used to be even cleverer, though no wiser, and even more insufferable before all this. I'm just a PFC in the trenches nowadays, a backroom boy, but let me tell you this. I don't care what streets you've blocked, what cops you've protested, what stores you've looted, what 10K a pop lectures you've given, what New York Times thumbsuckers and New York Times bestsellers you've written, what race hustles you've run, and what fashion marts you've burnt down, and what Jew-hating mobs you've whipped up, what identities you've appropriated for the sake of academic advancement until you got caught, what made-up awards you've been given, what lectures and worksheets you've handed out to the HR departments of corporate America, what hearings you've badgered witnesses at as a legislator, what protests you've marched in, what virtue you've signaled, what anti-racism scams and rackets you've profited from, what tweets you've had go viral. Unless you have done 1/100th of the actual work done for actual justice by small-town trial lawyers, appellate attorneys, clerks, paralegals, case managers, people who run legal clinics for the poor, not a few of whom, no doubt to your surprise, are centrists or conservatives, you can shut the hell up. Find another vehicle for your egos and get the hell out the way of the people who are making a real difference because they actually believe in all the things which you claim are the problem. Due process, equal and colorblind justice under law, jury trials, actual evidence, the adversary system, the presumption of innocence, the burden of proof, reasonable doubt, and cross-examining witnesses no matter what identity or victimhood they claim and insist not be questioned. If you do know the law, do not lie about it to lay people for partisan advantage or any other purpose. Should you do, I do not envy you your chances on the day of direst judgment, not even if you answer in Welsh. And for the love of that God in whom you do not believe, shut your ignorant lay mouths about law when you are entirely inexpert on the subject. Now, if you'll excuse me, I have to get back to advising my old firm in yet another contest against petty tyrants with badges.